Hey, gun people. Well, I was looking at some of these cases on that I thought might be interesting, and I wanted to review this one, but I figured I'd make a recording of it and see how it went. So in 1986, Michigan State Police created a sobriety checkpoint aimed at reducing drunk driving. And I've already told you where I stand on this. I think it's a violation of the Fourth Amendment. It's unreasonable search and seizure. It's done arbitrary, and it's not done with probable cause or a warrant. Therefore, it shouldn't be allowed. But Supreme Court gets to rule on it, not me. The program included guidelines governing location of roadblocks and amount of publicity given to the operation. Before the first roadblock went into effect, Rick, a licensed Michigan driver, challenged the checkpoint and sought injunction relief because in Michigan, the lower courts, he won. Good for Michigan. They agreed that it was a violation, but it went to the Supreme Court. Let's see how that turned out. And here we go.
Now in number 88, 1897, the Michigan Department of State Police versus Rick Sitz. Mr. Casey.
Mr. Chief Justice, and may it please the Court, in a series of cases involving Fourth Amendment challenges to various traffic checking procedures, the Court has applied a balancing test which weighs the public interest against the right of individuals to be free from arbitrary interference. In these cases, the Court recognized that different procedures involve different balances and different constitutional safeguards. For example, probable cause is required for a search of a vehicle, either by a roving patrol or at a fixed checkpoint. A seizure of an automobile by a roving patrol is permissible if it is based on reasonable suspicion. And in Martinez-Fuerte, the Court held that seizure of an automobile at a fixed checkpoint is permissible without individualized suspicion if there are neutral and objective guidelines which limit the discretion of officers in the field and limit the nature of the intrusion. The case today presents no new legal issues. The only question is whether Michigan's temporary sobriety checkpoints are like the roving patrols in Delaware v. Prowse, or, as we argue, are more like the fixed checkpoints in Martinez-Fuerte, in which no individualized suspicion is required.
Mr. Casey, this action was brought as a facial challenge of some kind to the program, and the plaintiffs in the case are simply citizens who drive in Michigan.
That's correct.
No one was a plaintiff named in the case who had been stopped at a checkpoint?
The complaint was filed before any sobriety checkpoints had been operated.
Do you think that the plaintiffs have standing?
I believe they do.
Why?
The case was brought under the Michigan Declaratory Judgment Action by the plaintiffs in their capacity as licensed drivers in the state of Michigan, who alleged that if sobriety checkpoints were operated, there was a very great likelihood that they would be subject to the checkpoints. We agreed. If the checkpoints were operated, these individual plaintiffs would be subjected to them. We think there's a sufficient case or controversy to confer standing in both the state courts and in this court, even without waiting for a particular operation of the checkpoint.
Suppose a police department has a policy of applying chokeholds to people resisting arrest. Would any citizen have standing to challenge that practice?
In that case,
on the theory that he might be arrested and a chokehold applied to him.
The likelihood of any individual citizen being subjected to that police tactic is not as high as the likelihood that individual citizens in Michigan will be subjected.
Most everybody drives. Not everybody gets put in a chokehold by the cops. So I agree with this attorney.
To sobriety checkpoints. So we think our case, the plaintiffs do have sufficient standing to permit the court to address this question as a facial constitutional challenge without waiting for an individual to be arrested and then try it as applied to him.
Well, surely the state courts thought that there was standing for purposes of a state action.
Yes, that's quite clear. There was no challenge by us to the state.
And you were on the losing side.
That's correct.
So you're stuck with a judgment.
So far we are, yes, Your Honor. There is no dispute as to the operation of the Michigan checkpoints. They were intended to promote the public health and safety by reducing the appalling number of deaths and injuries and the staggering economic costs.
Remember, when government starts quoting public safety, you know you're about to lose freedoms, and you know the government's about to gain power.
Caused by alcohol-related traffic crashes. The committee which drafted the Michigan guidelines observed that in 1984, in Michigan alone, there were 800 deaths, more than 28,000 injuries, and more than $350 million in economic costs caused by alcohol-related traffic crashes. The sobriety checkpoints are intended to increase the public's awareness of the nature and severity of the problem of drunk driving. They are intended to apprehend people who are driving drunk at the time and to deter others from driving drunk in the future. The sobriety checkpoints use neutral objective criteria which were carefully designed to minimize the discretion of the officers in the field and to minimize the extent of the intrusion. All oncoming traffic in the selected location is alerted by way of an extensive series of signs, flares, lights, traffic cones, officers with reflective vests. Traffic is funneled into one lane of traffic. The drivers are stopped for between 20 and 30 seconds while a police officer approaches the driver, identifies himself or herself, explains the nature of the checkpoint, and hands the driver an informational brochure and a public opinion survey.
How many of you have been through a checkpoint that it took 20 or 30 seconds? That's just a flat-out lie. It takes 2 minutes for them to start funneling and for you to get in line, and then it takes another 5 to 10 minutes before you're ever through it. This 20 and 30 seconds, I can't believe not one justice called him out on that. That's just total BS.
Survey card, which the driver is requested to return. If there are no visible signs of intoxication, the driver is then free to go on his or her way. If the officer observes articulable signs of intoxication, he may direct the driver over to a safe area for further investigation.
When you stop a police officer, aren't you normally very nervous if you're perfectly sober?
Not necessarily. Some people might be nervous. Others might feel reassured by the fact that...
I don't know who he thinks is reassured. Most people that have any contact with the police in today's date is extremely nervous, and they should be. Because if they drop a pickle from their whopper, they'll be shot 14 times, and the officer will be claiming he was in fear of his life.
This is going on. In the Maryland study, which our committee relied on and examined very closely, public opinion survey cards were returned by the drivers who went through the Maryland survey. And I believe the figure was 87% of the cards which were returned indicated that they were not opposed to the checkpoints. And
well, that's a damn shame that 87% of the people are sheep. And those are the 87% that turned in the card.
I'm
Most
still
people...
learning about sheep questions.
Oh, crap.
Try asking
Alexa.
Tony a sheep fact to learn more about them.
Alexa, shut up. Sorry about that. So, 87% of the sheep were obviously the problem.
90% of them felt that there was some deterrent effect.
Oh, the police have stopped you.
Not necessarily. Some drivers may feel that. Well, we don't think that that's the determining factor in whether these are constitutional, however. There's a legitimate, very serious societal problem here.
Government's always good about telling us what the problems are and telling us how they need more money and more ability to seize freedoms so they can stop the problem. When in fact, 99% of the problems are created by government, for the benefit of government, to expand government. Man, I wish they would teach this in school.
To some extent, these are an intrusion on the motoring public, to be sure, but we submit that they were very carefully designed to be a very minimal intrusion. And when you weigh that in the balance of the serious nature of the problem, we submit they are reasonable.
Does Michigan use any kind of checkpoints for vehicle safety check requirements?
That type of checkpoint is authorized by the same statute which authorizes sobriety checkpoints. And my understanding is that such checkpoints have been operated on occasion in the past, but there is no standard procedure. They're not operated very frequently.
What if there were a situation in a particular area, for example, in the city of Detroit with high crime?
Oh, the city of Detroit's got high crime and great many shootings? Wow. Maybe they should elect liberals and have high gun control so they can fix all those problems. Oh, I'm sorry. They already do that. I digress.
And a great many shootings. Do you suppose that Michigan could set up a pedestrian checkpoint and frisk people for weapons?
I believe they already did that in New York. It was called the stop and frisk.
I doubt if they could frisk them. Get into the case of Terry versus Ohio, when a police officer can pat down a person on the street. What we're saying here is that the checkpoints are located at times and in places where there is a demonstrated history of alcohol-related crashes. All accident statistics are fed into a computer, and the checkpoints are placed in locations where there's been a history of accidents or a high arrest rate. In that instance, the same type of balancing test would apply. You'll have to
i.e., near any bars or any establishment that sell alcohol.
look to the nature, the severity of the problem, the amount of the intrusion, and does the police procedure have reasonable effectiveness in addressing the problem.
Are the same standards applicable to a vehicle safety inspection stop and a sobriety checkpoint? Same balance?
I believe they are.
Same legal standards, same rules?
Correct. The purpose is a little different, but the court has recognized in Delaware v. Prowse, for example, that the state, state has a very significant interest in assuring that drivers are properly licensed and have proof of insurance and registration, and that vehicles have the required safety equipment.
And I think those are absolutely unconstitutional too, because they're stopping people to check things without a violation, without probable cause, without reasonable suspicion. They're just stopping everybody. And somehow that has become okay. And I don't like it. I don't agree with it, but I'm kind of being known as anti-gun. For those who haven't watched my other video on this, the justice that asked the question, their face lights up. So you'll know who's asking the question when it says their name.
The nature of the problem here is even more serious than that. We're talking about hundreds of deaths and tens of thousands of injuries every year.
Hundreds of deaths and tens of thousands. We don't have that many from guns. They're not trying to get rid of alcohol. They don't have no alcohol-free zones. You don't have to have a background to buy alcohol. But they want the guns. What is the difference between that?
In Brown v. Texas, the court applied a balancing test and discussed several of the traffic checking cases. All the parties below and in the state courts, we used the Brown v. Texas articulation as the standard. There, the court identified three factors which go into weighing whether a particular procedure is reasonable or not: the gravity of the public concern, the extent to which the seizure advances the public interest, and the severity of the interference with individual liberty.
Just based on what he just said, they ought to be disallowed.
We believe that the record in our case is sufficient to demonstrate that the checkpoints are reasonable under all three of these factors.
I don't agree.
Gravity of the public concern is undisputed by plaintiffs here. It's widely recognized. The key point where the state courts went wrong, we submit, is in its conclusion that the checkpoints were not effective enough.
I don't think checkpoints are effective. First of all, they publicize them. Anybody drinking avoids them. It usually affects people who don't know about it. And I would like to see the stats, and why aren't they showing the stats on how many drunk driving they have prevented because of these checkpoints? You notice they don't show that.
The court in Michigan said that we did not prove a sufficiently high arrest rate. We did not prove long-term deterrent effects from the operation of the checkpoints, and we did not prove that they were the most effective method the police could use. We submit that the state courts severely distorted the appropriate balancing test when they held us to that kind of impossible burden.
Impossible burden. Well, crap, if we can't burden the government to prove when they steal freedoms and when they violate the constitutional Fourth Amendment to unreasonable certainty, if we can't hold them to that burden, What's the point?
We think that in this context, where you have a very serious public problem and minimal intrusion, all that needs to be shown is reasonable effectiveness. Is there sufficient basis for the state officials reasonably to conclude that sobriety checkpoints would be reasonably effective in addressing the drunk driving problem?
Is it agreed that this is a seizure?
Yes, it is.
And it's agreed that and the argument is whether it can be done without any articulable suspicion, isn't it?
That's correct. In several cases, the court has articulated standards in dealing with the effectiveness of various procedures. In Delaware v.
Mr.
Crouse,
Casey, when you say this is a seizure, you mean it's like an arrest or it's like a Terry stop?
it is less intrusive than a traditional arrest.
See, he just kind of gave the guy out. See, one justice put him on, it's a seizure with no probable cause or no articulable suspicion, and you're seizing somebody. How do you get around that? And now, he just gave him an out for that.
Cars are required to stop for a period of 20 to 30 seconds.
He's going to keep repeating this lie. I've been through no less than 5 DUI checkpoints, and I've never got through it quicker than 5 to 10 minutes.
That's a checkpoint. All cars coming through in a certain direction are required to stop. In Michigan, our checkpoint guidelines are set up so that cars can turn off before they enter the check lane. And on the one checkpoint which was operated, I believe the record shows that 6 cars either made U-turns or turned off before.
Well, in California, they block the road so you can't turn off, and we actually had chase cars, so when somebody did turn off, that was probable cause to stop them on why they were avoiding the checkpoint. So Michigan may be a little different, and if only 6 cars made a U-turn, I would argue, how effective is a checkpoint if the people that are affected by the checkpoint are allowed to make a U-turn? How can you say it's effective? Would have been my argument.
Before they entered the checkpoint.
What is the purpose of that?
The checkpoint guidelines were developed with every effort to minimize the intrusion, and that, I suspect, was one element of...
That might have been why they were developed, but I guarantee you when cops are doing it, we are not looking at the minimum intrusion. We're looking at getting stats, we're getting overtime, we're there, and if you want more overtime, you better show that you can produce, and you better get out there and have a lot of people and earn your overtime. And if you don't do anything, then they're going to take the overtime away. And if we don't catch anybody, they're going to say they're ineffective and they're going to go away. So it may be designed for limited intrusion, but it's not enforced and carried out with limited intrusion, I assure you.
Let the drunks get away.
It would be easy to design a more effective checkpoint than we have. But to do that would probably require greater intrusion.
Oh, so he's admitting that it's ineffective. Isn't that what he said earlier they needed, is to show the effectiveness, and now he's just admitted they're ineffective?
The balance that the Michigan officials chose was to give as much weight as possible to minimizing the amount of intrusion.
Would the U-turn provide probable or articulated suspicion for a stop?
Not by itself. If the U-turn was done in a fashion that violated traffic laws, or if there was some erratic driving or some other articulable suspicion,
yeah.
And the guidelines say that that would be enough.
Yeah, because as a cop, every time some car made a U-turn to avoid a checkpoint, cops always were looking like, I wonder if he made that U-turn safely. Maybe I'll go check on him. Maybe the light scared him. Maybe there's something going on. There's 1,000 ways I can justify PC to stop you when you make a U-turn to avoid a DUI checkpoint.
Pursue the driver. But just the mere fact of a lawful U-turn would not be.
BS.
Under the Martinez-Fuerte case, the court said that all cars coming through the checkpoint could be seized, and the officers running the checkpoint could direct some cars to another area for further investigation without any reasonable suspicion. Our checkpoint is even more protective of individual rights than that. The officers do not ask any questions. Drivers are not required to show identification.
That is not the case in California. They are required to show their driver's license, and we're authorized to run their driver's license to make sure it's valid and they're driving with a correct and proper driver's license that's not suspended.
There is really no communication from the driver required at all, unless there are some visible signs of intoxication, at which point the car would be directed to a safe area for further.
Is the driver required to roll the window down?
He's not required
Oh,
to.
please.
Is he advised that he doesn't have to?
No, he's not advised.
Because if he didn't, how would you ever find him?
There are many ways a trained police officer could take notice of articulable facts involving intoxication. Uncoordinated physical.
How many people with one brain cell thinks that if you pulled up to a DUI checkpoint and refused to talk to the officer, to roll down your window, or not show your ID, how many people think that you would the officer say, okay, thanks, have a nice day? Are you kidding me? I can't believe he's even saying this with a straight face.
Movements, eye motion, perhaps he's got some beer in the car with him. There are many ways, but our checkpoints require an officer, before they have further suspicion, to have articulable signs of intoxication. I believe the Constitution perhaps does not require even that high a standard. In Martinez-Fuerte, the court said that some cars could be directed for further inquiry without reasonable suspicion.
Does refusal to roll down the window itself constitute part
Not
of the
by itself, no.
suspicion? Well, is it one of the factors?
It could be one of the factors. In several cases, in the Cortez case, for example, this court discussed the idea that a trained police officer can observe behavior which might appear innocent to an untrained person, and from that behavior, the trained officer can make inferences and deductions which would form a basis for a reasonable suspicion. That's why it's so hard to say that any one factor would or would not be the deciding factor. There are command officers on the scene who are involved in the decision whether to send a driver off for further investigation.
Let me explain what that command officer on scene meant. That means a sergeant there that doesn't want to be bothered, and if somebody pulls up and says, I want to speak to a supervisor, an officer yells, hey, he wants to talk to a supervisor. He goes, good, have him pull over. And now you've got reason to detain him because he requested to see a supervisor. That's how that works. That's not being talked about.
It's not up to the individual officer in the field, and it is structured by the guidelines themselves.
Under the standard procedure, is an officer stationed in a place where he can follow someone who makes a U-turn?
There are several police cars to be stationed before and after the checkpoint, so a car could turn and follow a car that made a lawful U-turn, yes. The case we principally rely on, of course, is the Martinez-Fuerte case. We think our checkpoints are constitutionally indistinguishable from the checkpoints there. The goal is different here. It's to prevent drunk driving and prevent the harms that drunk driving causes.
Of course it's to prevent. It has nothing to do with government control, stopping, looking for other crimes, fishing expedition, trying to gain stats, trying to find other violations so you can collect more taxes. Has nothing to do with that, people. It's all about keeping you safe. Don't you feel safe when you have the government trying to help keep you safe? Wow.
As opposed
Casey and Martinez-Fuerte, were the motorists aware or generally advised of the location of the checkpoint?
In that, it was a fixed checkpoint, which was permanently
so
based
people
on.
Would have reason to know where it was. Now,
Right.
I guess in Michigan that's not the case. You wouldn't know as a motorist
There is
where it would be set up.
There's general publicity given to the general area. Say in Saginaw County there would be one. The press would be advised of that. But as to the specific location on a specific street, no, that would
Does
not
that
be.
make a difference in the constitutional balance?
I don't believe it does. Martinez did not have
Of course you don't
that.
believe it does. You're arguing that you want more power and control. You're not going to believe anything is against the Constitution as long as you get more power and control. This is why you need conservative judges that understand the Constitution is restrict government power and it should never be, wavered, or government power should never be easy to gain and grow.
Aspect. That is really the only factual difference. We submit that while our checkpoints are in operation, however, they operate the same as Martinez-Fuerte. Drivers are given sufficient notice. They are not surprised. There are the signs for up to half a mile in advance. There is the opportunity to turn off. There is no basis for the trial court's finding that there would be fear or surprise in the motorist.
Mr. Casey, you said general notice is given. A notice is given that a checkpoint will be established somewhere in Saginaw County?
Yes. And
what you're talking about, several, Bay City, several
yes,
cities.
In a general area.
But all that's known in advance is that it will be in Saginaw County.
Correct. If we did not have that, it would greatly diminish the deterrent aspect. If every driver knew where it was going to be, it would be easy to avoid.
Yeah, because we don't want the drivers knowing. We don't want them turning around. We want to trap and funnel them because we're on a fishing expedition and we don't want them to be able to avoid it. Man, I just, this is such a no-brainer for me that these are unconstitutional. But Supreme Court gets final say. We'll see what they say.
So again, we've tried to balance the effectiveness against the intrusion. I want to save a few minutes for rebuttal, but I just want to emphasize that we're asserting that the proper balance test here shows that this is a serious problem, it is reasonably effective, and it is
serious problem. Serious. Government has to get involved because we can fix any serious problems, right?
Intrusive. Thank you.
Thank you, Mr. Casey. Mr. Nightingale, we'll hear now from you.
Thank you, Mr. Chief Justice, and may it please the Court. We join in Mr. Casey's analysis of the legal principles that govern this case. If the Court please, I will focus first on those features of the problem of drunk driving in this country that have made it so resistant to traditional law enforcement techniques, and on some of the reasons why sobriety checkpoints have been widely recognized as important elements of effective drunk driving programs. Mr. Casey indicated there has been no dispute in this case that the problem of drinking and driving is a very serious one. It's important, nevertheless, to pause for purposes of the Court's balancing test and to appreciate just how grave that interest is. If one were to prepare a list of the most important and serious threats to public health and safety in this country, drunk driving would have to be at or near the
top of the list. No calls for outlawing alcohol, no calls for seizing alcohol, no calls for making alcohol just absolutely illegal to have one drink and drive, no calls to stop restaurants from serving alcohol after a certain time. No. It's the serious problem in the world. Yet they are trying to get the guns every chance they get every time there's one incident, even though there's thousands of incidents where law-abiding citizens protect themselves, stop their kids from being kidnapped, stops their family from being raped, stop their house from being burglarized, and then becoming victims of strong-arm takeover robberies. There's thousands of cases. That doesn't matter. It only takes one gun case, and suddenly it's a grave problem, and they want to take the guns. Such a disparity on, really, where their priorities are.
In 1988, 47,000 people were killed in traffic crashes in this country. Of the roughly 62,000 drivers involved, 25% were intoxicated legally at the time of the accident. Alcohol was involved.
Nightingale, going back to Justice O'Connor's question, is the problem any less serious with regard to firearms?
I believe that there were more people killed in traffic crashes, Your Honor, than there were by murder.
Only 25% of those are alcohol-related, I thought you said.
Well, in 25% of the drivers involved are legally intoxicated. In the case of 50% of the fatalities, alcohol is involved, and that refers to some level.
How do guns compare? How do firearm danger compare with that?
I believe that the number of murders in the country, and this is a rough recollection of something I read along the way, is on the order of 20,000. It's both are very serious problems.
How about drug traffic? I suppose you would take the position that that's an equally serious national problem.
It's certainly a very serious national problem.
So can the government set up stop and frisk points for pedestrians in drug use areas of cities?
Your Honor, a frisk is a much more intrusive form of interference with.
I don't think it's that much more intrusive. You're stopping a person's free will to movement. They are not allowed to leave, and you are requiring them to give evidence against themselves because you're observing them. So therefore, by talking and communicating with you, you're asking them so you can see whether they're slurring their words, whether they have the smell of alcohol, whether their faces. You're looking for all the signs, and you're stopping and seizing them with no probable cause. I'm not sure it is much more intrusive to do a stop and frisk, other than you're actually putting hands on a person on a frisk versus you're not necessarily putting hands on when you stop them and seize the whole car, their passengers, and stop their freedom of movement.
Than a traffic stop. Traffic stop is a well accepted form of
it's too well accepted.
In the Martinez-Fuerte case, the court noted that it was a well-established practice whose utility had been accepted as an incident of travel on the roads. And it is a very, very minimal interference with
every
Fourth
time
Amendment.
He talks about ignoring the Fourth Amendment, it's very minimal. It's minimal intrusion. It's very minimal, very minimal. We're just doing it a little bit. Slippery slope. Government is supposed to be restrained. Government, it's supposed to be hard to seize freedoms. The Constitution was made to hold government accountable, not for government to say, well, we're just going to impede on it just a little. We're just going to trim a little fat off it.
That you have a license to walk along the sidewalk, can it?
No, Your Honor, I wouldn't think so.
And it does have the right to insist that you have a license to drive.
That's true. Driving is a very highly regulated activity in this country, in keeping with the risks that it presents to others on the road.
So it's not inconceivable that you might you might have a traffic stop not just for intoxication but for drug use. Does this seek to find out drug use as well?
I believe that, at least under the Department of Transportation's guidelines, as a result of recent regulation, that drug use and alcohol use are treated the same.
Well, speaking of statistics, I think there are more deaths by automobile accidents than in all the wars of this country put together. This was spelled out in an opinion of this court, which you haven't cited.
Right. Yes, Your Honor, and also in a concurring opinion that you wrote, I believe.
Nightingale, how do we decide how effective this is? I suppose that goes into a reasonableness calculation. How does a court make that judgment? Are we limited to the record in the trial court here, or what?
I would think not, Justice Scalia, in this sense. In a number of the court's cases, you've had to assess necessarily the deterrent effect of various programs. In the Mackey versus Montran case, which involved whether drivers could have their licenses suspended for refusals to take breathalyzer or blood alcohol tests, the court indicated that they had a significant deterrent effect. In the Berger case, there was discussion about the deterrent value that would be lost if warrants were required.
When the implied consent first came out, if you said no, I don't believe there was a penalty. I thought it was voluntary. And now, when you get a license, it's mandated that in order to accept the license, you must agree to submit to breath tests. See that slippery slope?
Searches that were involved there. It's a common element to the court's decisions in this area, both to consider the deterrent effect of programs and also...
Have we done it in cases when the trial court has reviewed evidence on the issue and the record has been developed and we said, well, that's just the starting point, we'll go off on our own and figure out what evidence we can find on our own? I know we've done it in cases where a facial attack and no evidence at all in the trial record, but...
Well, I think it's important to focus on the sort of trial record that was developed here. This is not a record that gauges the effect of this particular program in action. And this is a record that focuses on the potential of the program.
Whatever the record was is what the state put in order to justify the program. They had an ample opportunity to put everything in they wanted, didn't they? Maybe you could have tried the case better, but you didn't try this case.
That's true, Your Honor, but not necessarily true that I could have tried it better, but it's certainly true the state had an opportunity to put in the evidence. The issue really is...
Lawyers never like to admit they're wrong. He didn't want to say he could have tried it better because lawyers think they're perfect and they did everything right.
The approach the court must take in this area results from the generality of the court's holdings. I mean, were the court to take this situation, were the court to say that this presents only an issue of fact, the effect of the court's decision would be limited to these two parties as of this time. And the court has never viewed its role in the Fourth Amendment area as limited, as so limited.
Viewed our role as just deciding the case or controversy that's brought us for decision, I suppose.
Well, that's certainly true, but I think in this case the question is whether there is a reasonable basis for a conclusion on the part of the state authorities that this is a potentially effective means of reducing drinking and driving.
Is that all it takes, a reasonable basis, in order to make the weighing of whether this is a reasonable intrusion upon privacy or not? Suppose I disagree with the state. Suppose I think it seems to me if you took these 17 law enforcement officers, however many were used in this stop, and just set them out on the roads to look for people weaving, you'd do a lot more good than
Absolutely,
having them
100% correct.
At this traffic stop for a number of hours, and they pick up 2% of the people that went through?
In this case, Your Honor, people...
Suppose I think that.
I think that...
Do I have to say, well, the legislature might have thought otherwise? Why can't I just say, in my view, it's unreasonable to do it this way. You should do it another way.
Because the test isn't that... the test is not that searching at this stage, where the issue is the face of the program against the background of a
very minimal intrusion.
Minimal intrusion on privacy and a very, very constrained limits on discretion. There are good reasons.
But it's still not clear to me what we look to. How do we decide reasonableness?
It's easy for me. It's not reasonable. You're detaining and stopping someone against the Fourth Amendment without a warrant, without consent, and without exigency. Therefore, it's unlawful unless you go get one of the things that you can stop people for.
I believe that you look...
Are these statistics irrelevant?
I believe that the statistics confirm what common sense suggests in this area. In other words,
government always talks about common sense when they want more power. When the citizens want power, it's reckless, it's dangerous, they have to look out for us for public safety and national security. But when they do it, when they want more power, it's common sense. Wow.
We do look at the statistics. They are relevant.
I think you may look at them, yes. These are legislative facts involved here. Facts. Ordinarily, the court reviews, takes a measure of the deterrence, and in this case, we believe that you can look at the statistics to educate common sense.
How long was the program in operation before the suit was brought?
There was one checkpoint operated.
For how long?
For about an hour. 126 cars were stopped. One driver ran the checkpoint. One was referred to the safe area. Two were referred to the safe area, one of whom was found to be intoxicated and was arrested.
And then it was stopped because the court enjoined it?
That's correct. The complaint was filed before the first checkpoint was operated, and then the program was enjoined after only
Good
a
for
single
that
checkpoint
court.
had been run.
Mr. Nightingale, I'll have to take back what I said. You did cite Perez in a footnote.
Now, why, getting back to Justice Scalia's question about why it would be reasonable for the court to put a program like this in place, experience demonstrates that only between 1 in 200 and 1 in 2,000 drunk drivers can be apprehended on an average weekend night. And therefore, it's been the focus of efforts to improve on the situation in this area, to achieve more visibility, to achieve a more impressive reminder of the state's commitment to
That means the government wants to show a show of force that we are out here, and we want to intimidate you and fear you into complying. That's what that means, in my mind.
Thank you very much.
Thank you, Mr. Nightingale. Mr. Granzato, hear from you.
Mr. Chief Justice, and may it please the Court. There are two reasons why the decision of the Michigan Court of Appeals in this case should be affirmed. First is based on this Court's decision last term in Von Raab, and also the Court's decision in Skinner. In that case, in those two cases, this Court indicated the situations under which the Court would refer to the balancing test in determining whether a particular Fourth Amendment intrusion was in fact unconstitutional. In Von Raab and Skinner, this Court indicated that where the particular type of intrusion serves law enforcement needs, serves governmental needs beyond the normal need for law enforcement, then the Court would refer to a balancing test. This case presents for the first time, I believe, in this Court, a situation in which a suspicionless, warrantless seizure is being conducted solely for one purpose, and that is to enforce the criminal law.
That should be the end of the case. He's correct. It's absolutely wrong, and it ought to be affirmed. But that's my opinion.
Under the decisions of this Court's last term in Skinner and Von Raab, this Court need not even refer to the balancing test in light of the fact that there is no dispute that the reason this particular seizure takes place is to, in fact, enforce the criminal law.
How about Martinez-Fuerte?
Martinez-Fuerte, Justice Powell, in his decision in that case, in a footnote, indicated that many of the seizures which take place at the border search or the border stops resulted in something which did not go to a formal charge.
But it was enforcing the criminal law, nonetheless.
That's correct. Martinez-Fuerte is, of course, a criminal case. But to go back to Almeida-Sanchez, 3 years before Martinez-Fuerte, Justice Powell, in his concurring opinion in that case, indicated that only 3% of all cars that were stopped, of all persons who were stopped for violations of the border, illegal aliens, only 3% of those people were in fact prosecuted. Therefore, we have a situation which is just like New York versus Berger, in that, indeed, there's an overwhelming non-criminal purpose to the stops which took place in Martinez-Fuerte.
Well, to say that they're end up not being prosecuted doesn't mean they weren't being used to enforce the criminal law. That was the only law in the books there was that was being enforced, wasn't it?
But it wasn't being enforced through means of a prosecution.
Well, why does that make any difference?
Well, it would make a difference.
I mean, did the cases you rely on last year make that point?
Excuse me?
Did the cases you rely on that we decided last year, Von Raab and the other Skinner case, make the point that you're making?
Yes, they did, in fact, because in the Von Raab case, for example, there was no chance of there ever being a criminal prosecution in light of the fact that the testing which took place in Von Raab couldn't be used unless by the agreement of the person whose test was being taken in a criminal proceeding.
Well, but I thought the point you were making was that Martinez-Fuerte was really not a criminal case because so few people were prosecuted under it.
No, that's not what I'm saying. This Court has decided in New York versus Berger that a particular type of scheme can have both an administrative nature and a criminal nature. Martinez-Fuerte fits squarely within the dichotomy which was drawn in this Court in New York versus Berger, because as Justice Powell indicated, only 3% of these cases actually result in prosecution.
Well, but that doesn't mean it's an administrative scheme. It's not as if there was some administrative procedure that was being enforced in Martinez-Fuerte. It was just different levels of the criminal process.
Well, I would, in response to your original question, Mr. Chief Justice, I would also indicate to the Court that this Court has indicated since Martinez-Fuerte that there is a nexus to the border which allowed the Court to make the decision in Martinez-Fuerte as it did, and that's the case of Montoya de Hernandez. Because in that case, the Court indicated that the decision in Martinez-Fuerte was in fact connected to this country's vested right to protect its borders. And in that sense, the whole concept of a probable cause or reasonable suspicion requirement was automatically out of the Martinez-Fuerte case to begin with.
Mr. Granzano, what do you do about truck checkpoints on which exist on many state highways, requiring trucks to pull over to determine whether they're overloaded and whether their safety equipment is operational.
To some extent, those cases may fall within the balancing test, even under this Court's decision in Von Raab and Skinner, because they may involve, in particular states certainly, non-criminal prosecutions, or at least a situation in which there is both administrative
okay, I'll make up one. It's criminal. If they catch your truck with too much weight on it, you're going to be cited criminally, or with unsafe brakes.
Well, there's another construct to the Fourth Amendment which may come into play in a situation of a truck and a weigh station, and that is the heavily regulated industry concept, which has been developed by the Court and applied in a number of cases. That may well take it outside.
Heavily regulated industry? I don't know. You need a driver's license and a truck driver's license, just as you need a car driver's license for a car.
But it is, it is regulated because of the weight of the vehicle. That's why the weigh stations exist to impose certain restrictions on the weight.
Seems to me circular. Since the weigh stations exist, it's a heavily regulated industry, which justifies the weigh stations.
No, the heavily regulated industry construct, which this Court has adopted, is based on one thing, and that is a piece of legislation, or a number of pieces of legislation. The weigh stations have nothing to do with whether it is in fact a heavily regulated industry.
How long certainly there are a great number of regulations of automobiles, safety requirements, and where they're contained in statute.
Indeed, and as I pointed out in my brief, there are certain vehicle checks which could exist in Michigan in response to Justice O'Connor's question to the petitioner's attorney. These particular stops in Michigan have in fact been decriminalized recently, as Colonel Hogue testified in his testimony at the trial in this case. In that situation, as I've indicated in my brief, those types of suspicionless, warrantless stops would be subject to the balancing test which this Court has developed.
How long had this checkpoint been in operation before it was stopped by the court order?
Let me just say, I want to correct one thing. This check lane was stopped by stipulation of the parties after the first time that it had been.
Were you sleeping during that part?
We actually brought this case prior to the imposition of the first check lane to try to prevent it from taking place at that time. It had been in operation for
If you sought to enjoin it before it even was established, then how did you expect the state to have any statistical evidence?
I'll tell you why. Because it said that they, in order to do a program and in order to do this program, they have to show that it was effective. That's why the program was started, because they said it would be effective.
Kennedy, this program...
The sooner you bring it, the better off your suit is, because the state has no statistics to back up what they're doing?
No.
You slammed them there.
No, not at all. This program was copied from a program which was developed by the state of Maryland and the state police of Maryland, and copied very liberally, I would say, from that program. And the Maryland program had been in existence for approximately 4 years. In addition, there was
Maryland
a considerable
is a much more left-wing state, I guess.
Experience outside the United States prior to the Maryland program, which analyzed the effectiveness of these sobriety roadblocks. And that is the type of evidence which was presented in this case through Dr. Ross. Dr. Ross, who has analyzed extensively the studies that have been conducted worldwide on the subject of sobriety roadblocks, testified in this case. And what he testified to went directly to the balancing test, which the court applied in both the Michigan Court of Appeals and...
So it was improper, in your view, for Michigan to even enact this statute and to try to administer the roadblock on its own and gather its own statistics?
That's correct.
Mr. Granzotta, would it have made a difference if these weren't stops along the way, but if these were, suppose they set up at the entrance to Michigan highways, checkpoints at which they would check your car headlights before you were allowed on it, the brakes.
What the hell, Scalia? Are you trying to get more you want to give them more ideas to start doing checkpoints on on-ramps so we can find people and intrude in more? What the hell kind of question is that?
And the sobriety of the driver. Suppose they do it at a toll booth on a state toll road. When you come up to the toll booth, they check your safety of the car and the safety of the driver. Is that okay?
Well, my position is that with respect to an investigation, and attempting to find criminal wrongdoing, that there is something fundamentally different about that and a stop for a vehicle code violation or a toll booth.
Well, it's hard to separate the one from the other. I mean, it's the same at the truck stops. They're doing two things. If you are there in violation of the law, you'll be penalized, but they want to get you off the road also. Isn't that the purpose of these stops? I mean, you say it has a purely criminal purpose. Well, it isn't just to put you in jail for a violation. It's to get you off the road
why don't
because
we
you're
just start
drunk.
checking people when they leave their house? Because we don't want them to be drunk or a danger in public. So officers should just be able to check you when you leave your house to make sure that if you go in public, in the interest of public safety, that government should be able to check your sobriety and whether or not you're... I mean, the way the court's asking these questions, I'm like, man, you guys have already decided that you just think the Fourth Amendment is BS, and if you're in a vehicle, it's King's X. You can do whatever the hell you want.
Purpose is achieved through the enforcement of the criminal law.
Well, likewise in the case I just spoke about when they're checking you to get on the road. You mean it'd be okay if they checked your brakes and found the brakes were no good and said you can't get on the road? Go in peace, and you go home.
No.
But if they arrest you for bad brakes, then it becomes bad.
No. The first that you are describing is something that would, certainly in Michigan, in light of the decriminalization, be subject to the balancing test. The only point I would raise in light of Von Raab and Skinner is that if the purpose of the intrusion is to purely serve the criminal law, then that intrusion is unconstitutional without even resort to the balancing test. Let me go to the balancing test, which has been talked about at length. There are three factors which were analyzed in this case. The gravity of the public harm is the first, and on that we have no dispute. We did not bring this case to minimize the dangers associated with drunk driving in this country. What we attempted to prove, and did in fact prove to the satisfaction of the trial court in this case, was that sobriety roadblocks are just not an effective means of addressing that serious societal problem. We presented in this case the testimony of Dr. Ross. Dr. Ross is a preeminent expert in the area of deterring the drunk driver. What Dr. Ross testified to on one point was totally uncontradicted at trial, and that was that as a means of actually arresting drunk drivers, sobriety roadblocks are worthless. Sobriety roadblocks do not achieve significant numbers of arrests.
How did he define significant and how did he define worthless?
Well, it's not exactly defined, but what Dr. Ross, I believe, was talking about when he was talking about worthless is that you are removing a number of officers from a practice which does have positive effect, and that is roving patrols. You are taking officers away from that goal and applying them in a particular area to conduct...
Well, I'm surprised one ain't saying, well, why don't you not use regular officers and you bring in officers that aren't necessarily working and just pay them overtime? Then would it be okay? Because that's where they're going to try and go next, I'm sure.
Sobriety roadblocks.
Well, so if the state feels differently, if the state, after evaluating its enforcement proceedings, feels that the roving patrols don't do the job and that this checkpoint should at least be given a try, they're not entitled to do that if some expert takes the stand and says, I think differently.
No,
well, isn't that about what it amounts to?
No, because, Mr. Chief Justice, in this case, the witnesses called by the state, their own witnesses.
Well, no, but I was talking about Dr. Ross's testimony. You summarized it, I thought, and he said these were worthless because they didn't catch drunken drivers.
That's correct.
Well, and I take it you're relying on that testimony because you feel it supports the finding of the trial court. And my question to you is the trial court, on the basis of the testimony of someone like Dr. Ross, entitled to substitute its judgment for that of the state as to which of these procedures work best?
No. What is important about this case is that the witnesses who testified for the state in this case, the Colonel Hoke, who was the head of the Michigan State Police.
Well, are you ready to write off Dr. Ross's testimony then?
Absolutely not, because Dr. Ross's testimony was absolutely consistent with every piece of evidence presented in this case.
Well, okay, but you began by mentioning his testimony, so I presumed it was important to you. But now you seem to suggest, well, it doesn't make any difference what he said because other witnesses said the same thing.
He was saying that the doctor reaffirmed and agreed with the witnesses put on by the state that they were ineffective. But he wasn't allowed to finish.
It's cumulative, because Colonel Hoke testified that the program was not being developed to arrest drunk drivers, to actually remove them from the road. Lieutenant Fladseth testified to the same point. This program in Michigan is not developed to remove drunk drivers from the road. It is like the Maryland program which Lieutenant Cotton testified to, because
that's just to say that the purpose is not to enforce the criminal law.
No. It's clearly no. It is still to enforce the criminal law, because they
even though they don't remove them from the road.
They do result in arrests, approximately 1% or somewhat less than the cars which drive through a sobriety roadblock.
That's because people have a suspended license, or they have a warrant, or they have drugs in their car, or they have a gun in their car, and they don't want to wait for the stop, so they would rather take their chances running. So, and that's what the state really wants, is to be able to fish and catch anybody they can, because the real goal is not to catch drunk drivers or to stop drunk driving. Just like the real goal in gun control is not to stop gun crime. If that was the case, they'd lock people up forever if you used a gun in a crime. The real purpose is to get guns from good citizens, so only government has guns.
Those people will be arrested. Those people will be arrested. There will be criminal prosecution resulting from them. What everybody testified in this case. Totally.
What if you know from listening to the radio or something that there's a checkpoint at a very dangerous intersection that you usually go through, and you going to have a few drinks, so you just decide that you better not go. You should take another route. That would be sensible, wouldn't it?
Yes, it would be.
Don't you? Is there any evidence in this case, or could there be? How many people were deterred by their knowledge of a checkpoint, deterred from going through that particular dangerous intersection?
I'm sure all the drunks just called the police and said, "Hey, I avoided your checkpoint."
Well, is it sort of a just an irrational thought that a lot of people who might go through that intersection without the checkpoint don't go through?
The hypothetical
is that
you've
just
given
irrational?
me, the hypothetical you've given me is not the type of deterrence that the state of Michigan is after in this case. They are not looking for people who are circumventing roadblocks by taking another route. They are attempting to justify this program on the basis that it actually deters people from driving after they have been drinking.
Well, it deters them from driving through that particular dangerous intersection.
Well, that may be true.
They make them drive someplace else.
That is not the type of deterrence which I think the state of Michigan is looking for in this case either.
But is it something we can't look at or not?
Well, that's an interesting question in light of the factual record that's been made in this case. I would begin talking about the factual record by telling you that I am not at all afraid about all of the statistics and all of the studies that have been cited in the briefs of amicus curiae in this case. The statistics, the studies, do not establish that these sobriety roadblocks are effective. Nonetheless...
Well, what do we mean by the word effective?
They don't work.
Well, but that's a value judgment, isn't it?
No.
What do you mean when you say they don't work?
They don't work because there are two possibilities that these sobriety roadblocks can serve. One is to actually physically remove drunk drivers from the road. Everybody who testified at the trial in this case agreed. They don't work on that basis. We're not even instituting them on that basis. That's what the state police testified.
They don't work in the sense that they only arrest, 2% or something?
1% or less of the people going through these things.
Okay, well, but compared to what?
Compared to what could occur if the 15, 12, 17 officers who are dedicated to one spot were allowed to do what they normally do, which is operate on the basis of reasonable suspicion in a roving patrol.
But the state's argument here is that is even less effective.
The state can make all the arguments it wants on that point, but it's first of all contrary to the record, and it's second of all not even supported by any of the studies, I believe, that they've cited in their.
So the state, in order to determine how to deploy its resources in solving this problem,
the state's
has to come
always
in
interested in resources and solving problems, because that's what the state does. Really?
Statistical surveys that satisfy a trial court?
No, because what was introduced in this case was an attack on the causal relationship between number of arrests and the deterrent value of these sobriety roadblocks. What was established at the trial in this case, what the trial court found, was that there is a close relationship between the number of arrests and the deterrent value. We have a situation where the state comes into court acknowledging, although not before this court, I might add, since they've altered their position dramatically before this court, but they came into court saying that this program is not designed to perfect arrest because it really won't be that effective in perfecting arrest. But we want this program because it's going to deter. We presented evidence in this case to demonstrate that there is a close relationship, an undeniable relationship between the power to arrest under this program and the power to deter.
How many people did not drive who were drunk because of that roadblock?
It's a question which I can't answer.
Yeah, I know you can. But how many do you say they need to
see how government will, even though they're only arresting 1% of the people they stop, government is okay with throwing out the Fourth Amendment to unlawful search and seizure to get 1%. Government is going to say, we're okay with that 1%. And who are you to say that it isn't effective? Prove it. And since you can't prove a negative, you get laughed at. Because government will always want more power.
Would they need to arrest?
To be good for you.
Again, it is a question which never came up.
Well, you sure that this is wrong? Now, give me one that's right. You're sure that 1% is wrong? Well, can you give me what percentage is right?
A percentage, first of all, would be right, would be one in which the number of arrests, for example, per man hour out on a sobriety roadblock would be better than the number of arrests that you get per man hour in a roadblock.
How many arrests you get per man hour for dope in Detroit?
I'm afraid I can't answer that question.
You certainly can't. You just pick out one.
I wonder if it's so wasteful. If these checkpoints are so wasteful, why there's some 30 or so states in here.
You wonder that? Government's always wasteful because government's not spending their money. Government's spending taxpayer money. When the hell is government concerned about waste? How can you even ask that question with a straight face? Let me.
I don't know.
They're all just misled.
No, what is involved in these checkpoints, and reading the amici briefs that have been filed in this case, one point that appears frequently and dramatically is visibility. These are a very visible means of showing that something is being done on the drunk driving problem. In Michigan, I would suggest to you, Justice White, that this program was done despite the hesitancy of the Michigan legislature. It was done at the request of the governor of the state of Michigan. And in my estimation, it was done precisely because this type of law enforcement mechanism is visible. It doesn't necessarily work, but it's visible. It shows that somebody's attempting to do something about the drug testing, about the drunk driving problem.
Well, the states would rather have these 30 states apparently would rather have checkpoints than deploy the.
First of all, you sound like a statist, a damn liberal, because you're all for whatever the states wants now when it's costing money and impeding on citizens' rights. You're all for states' rights. but when it comes to gun laws, you're all for federal rights. Why is that?
I would suggest to you that the
wouldn't they?
principle...
Wouldn't they?
Would they? I would assume by their amicus brief that's
Yes.
been filed in this case. But I would suggest to you that perhaps they are more interested in the constitutional law that's going to be developed if this court approves this type of sobriety roadblock, because we get into the question of whether there can in fact be mass investigations of people. And in that sense, Mr. Justice White, we may have a situation where there is the end result of the court's decision in this case may be far more important to the law enforcement people in this country than any decision, any indication, let me say, that these sobriety roadblocks actually work in this country.
You want us to say that this is unconstitutional if there's a more effective way of apprehending drug
I'm not asking you, I wouldn't be asking you to say that. I'm asking you to say it's unconstitutional because it is. Because you're targeting people massively without any probable cause or reasonable suspicion. You are herding people into an area so you can conduct an unlawful search with no probable cause. And you're calling it minimally intrusive, and I don't agree with that. That's what I would say.
Precisely your answer to Justice Marshall. Precisely your answer to Justice Marshall.
No, it is not only, let me say, it is not only that it is the less effective way, let me say, than roving patrols. That's not the only point. The fact is that these types of seizures will result in
I would not be arguing on the number of, I don't care how many arrests it works. Unless the number is so flagrantly high that it's like, how can you argue it's not effective when we're arresting 90% of the people in the checkpoint? How can you say it's not effective? I don't care if it is 90%. It's not about the effectiveness. It's about the unlawful search and seizure and detention of mass numbers of citizens who did nothing for government to contact them or start an investigation on them. That is the bottom line in my book.
First of all, they're not going to accomplish what they want to accomplish. It's just not going to serve the purpose. In comparison, I will grant you, in comparison to what the police could be doing in other settings. But as this court found in Delaware versus Prowse, there is a sort of marginal utility, if you will, to the a police technique which has to be analyzed by this court. In Delaware versus Prowse, for example, the court found that the
it's 6 minutes till the end.
which were at issue in that case weren't going to result in a marginal increase in the problem, the crime problem, which the police were attempting to combat in that situation. The same is true in this case. The third prong, which I would like to address of the court's balancing test, it concerns the scope of the intrusion. And on this point, I think there's a couple of misconceptions regarding the position which the state has taken in this case. The state attempts to justify this program on the basis that this is a minimal intrusion for approximately 30 to 60 seconds. In fact, there are a number of other factors related to the intrusion which impact on the analysis which this court must apply in the balancing test. First of all, there is the point which has been made before with respect to the number of innocent drivers passing through these checkpoints. At its best, these checkpoints allow 99% of the cars to go through because these people are innocent.
But they were still detained with no probable cause. They were still questioned by government, and government was still trying to find and locate evidence that they could charge them with without any probable cause or reasonable suspicion. This is clearly unconstitutional. I can't even believe the justices are asking what they are.
In addition, there is another disquieting, I believe, aspect to these sobriety roadblocks which has come out in the evidence in this case, and that is there is a significant number of what I would call false positives which have been developed. In other words, the program works that people will go through these sobriety roadblocks, be stopped temporarily. That is the stop which the state represents as being very short in duration. In actuality, a number of people will be diverted to another
Correct.
area where they will be further investigated, including a number of tests. What the evidence from other sobriety roadblocks has indicated is that you have twice as great a possibility of being diverted to these for this further investigation and not being drunk than you have of being drunk when you're diverted to these.
So of those diverted, 1/3 are found to be drunk and 2/3 are released?
That's correct. After further investigation, obviously, and
more intrusive,
more extensive investigation that takes place. There is a point made by the state in this case with respect to the discretion which is allotted the people who conduct these patrols. The state argues that that discretion limits the scope of the intrusion which is involved in the case. We had testimony in this case from Inspector Fladseth of the state police, who indicated that when a person approaches this sobriety roadblock, that person can be diverted for further investigation for any reason or for no reason at all. Therefore, the answer that was supplied before with respect to failing to open the window, if somebody could be diverted for further investigation for failing to open the window, the answer to that question is yes, they can be, because Inspector Fladseth candidly acknowledged during the course of his testimony that the officer who is confronting the person driving up in the car can divert that person for further investigation.
For no reason.
For any reason or for no reason.
If only 1% of drunk driving are arrested in this manner, and 1/3 of those diverted are found to be drunk, only 3% then are diverted. Is that about right?
That's correct.
See, we're trying to justify minimal intrusion, minimum number of people diverted, minimal people getting caught. We're not bringing that up. Minimal people being prevented. We're not bringing that up. The only thing we need to do is drunk driving is a very, very serious problem, very serious, and government needs to ignore the Fourth Amendment in order to address this serious problem. Always excuses to steal freedoms and ignore the Constitution that was designed to restrain government.
I am also concerned about the scope of the intrusion which can take place in these sobriety roadblocks. Because if
people tell me I talk too fast. This guy talks too slow. I can get out twice as much information as this guy. He's so slow.
The stop itself. There are a number of necessary results which would obtain on the basis of prior decisions of this court, on the basis of Pennsylvania versus Mims, and on the basis of Brown versus Texas. There are a number of actions, conduct which the police can take in this situation, undeniably, if this court does in fact approve sobriety roadblocks, that is, the stop itself. We brought this case not in an attempt to demonstrate that drunk driving is not a serious societal problem in this country. What we attempted to show in this case, what in fact the trial
I want to stop on the serious problem of drunk driving. If the state was really concerned and government was really concerned about drunk people and drunk driving, they would be looking at how many fights there are in bars, how many domestic violence are related to alcohol, how many assaults are related to alcohol, how many other things are related to alcohol, and let's address the alcohol problem. But it's not. It's to impede free movement, and since vehicles and highways, and they've got a driver's license has listed as a privilege, and they know people have to get on a highway in order to make a living, they want to have as much control over those people on those highways as they can, and they're constantly looking for ways to seize, make it easier to infringe on people's freedoms when they're driving. That's what this is.
That sobriety roadblocks are not an effective means of combating that serious societal problem. Under the balancing test, therefore, what we have, I believe,
very serious,
is a serious problem. We have an intrusion which may be minimal in some respects, But it is an intrusion which
doesn't matter if it would accomplish things. It's an intrusion against the Fourth Amendment with no I mean, I keep saying it because that's the point that should be driven home here. You're stopping people and forcing them to consent to give information and evidence against themselves that they could be arrested for with no articulable suspicion of a crime. You're just doing it to everybody you can entrap in a checkpoint.
We would ask that on the court's balancing test, as it's been adopted, that these sobriety roadblocks be found unconstitutional. Thank you.
Thank you, Mr. Granzato. Mr. Casey, you have 3 minutes remaining.
I have nothing further to add, Your Honor.
Very well. The case is submitted.
Mr. Casey, excuse me. I do have a question. Do you agree with the statement that was just made that these parties at the roadblock could be pulled over for further investigation for any reason or for no reason? Was that the way this was done?
I don't agree with that. The testimony that he's referring
because
to...
Because that bears upon the scope of intrusion. Certainly. I had thought up to now that all we're talking about, the degree of intrusion, is being stopped. If that statement is true, the degree of intrusion without articulable suspicion could be as much as getting out of your car and having to walk a line and do all the other tests that they perform.
That statement is not accurate. In one sentence in a deposition, one of the deputies on a cross-examination said that there could be reliance on any number of factors or perhaps no factor. That's not what the law says. That's not what this court cases say.
But that's
not
what the
our
cops
guidelines
enforce.
say. That's not the law
and
in
that's
Michigan.
how you get minor slippery slope intrusions that shouldn't happen, and that's how you get government doing more extra and more intrusion. That's why the Constitution is there. Limit government at every chance and opportunity, otherwise they will run over citizens with their big jack boat.
If a driver is pulled over for further investigation for no reason whatsoever, they would be able to challenge that on an individual as applied basis. Under the guidelines and the way the Michigan program is set up,
they are pulled over for no reason, except the only problem is, if I don't end up arresting the guy and I have you pull over for no reason, there's no way for you to challenge because I didn't arrest you. So I may stop 15 people with no reason, and I may only arrest one person. Well, guess what? On that one person, I'm going to be a lot more accurate on my report and articulating what I saw and why I stopped him. And it's not going to be, well, it was just for no reason, and that's our practice, and we stop everybody for no reason, and we just got lucky on this guy. You think that's what the cops are going to testify to? Of course not.
Averted for further questioning unless there are visible, articulable signs of intoxication.
It appears in the text of the guidelines?
Yes.
Now the case is submitted.
Okay, case is submitted.
We'll hear argument.
What do you think? How do they rule? Is it legal? Is it constitutional? You know where I stand. Oh, disgusting conclusion. 6-3 decision. The faces in dark are the ones that said it is not constitutional. Scalia, you ought to be ashamed of yourself. Stevens, Marshall, and Brennan said, hey, it is unconstitutional. Good for them. These other 6 yahoos said it was not a violation. Absolutely horrible ruling, in my humble opinion. All right, hope you enjoyed it. We'll end that there.